welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we're back in Calloway County with Social Security disability attorney Jeff Roberts. Jeff, how are you?
I'm doing well. How are you doing today, Jim?
I'm doing well. Thank you for asking. It's been a little while since we've touched on Social Security disability. You handle motor vehicle accidents. You handle a lot of workers' compensation claims. But the other thing that you handle is Social Security disability claims. And with that being said, as we talk, there are a number of things that pop up after the case has happened, after the claim has been decided. They could look like a speed bump, or it could look like, oh my gosh, what's going on? So I thought from an attorney standpoint, you might be able to address that for the consumer to let them understand, no, it doesn't mean we've got a massive problem. It just needs to be answered or addressed.
Correct. There are some things that come up. They can certainly be problems. Sometimes it's just general things that occur. Sometimes there are issues that have to be addressed, and you may need to be, some of the ones you might be okay on your own. Some you're going to need to reach out to an attorney to help you out in that regard. One of the issues that comes up afterwards, and I usually try to have the conversation with my clients when we've been successful in their case, in one of the last kind of closeout meetings that I have with the client, is to address issues that can come up into the future from that. My experience is when somebody realizes or knows the possibility of something coming up into the future, when it does arise, it's not quite as stressful for them in that regard. So, one of the things is a continuing disability review. I think we've kind of touched on this maybe a time or two in the past, but if you're on disability, Social Security can review that in the future to see if you are still disabled. And so there's a couple of things that come into play there. They'll look at it and then kind of make a determination on whether they think you're still disabled. Sometimes they do that kind of behind the scenes, and you don't even know they are reviewing it. And then they will send you a notice if they think that you're no longer disabled. And so that's something when someone gets that notice in the mail, obviously there's a lot of concern. And there's a few things that you can do to kind of help with that process to make sure that when they do that review behind the scenes, it never gets to the point of, are you still disabled? From that standpoint. So one of the biggest things is to continue to seek medical treatment. They will look at it to see if you're still getting treatment for the conditions that were disabling for you in that regard. And if you are still getting the treatment for that, the records still show that you have those problems and are undergoing treatment on a regular basis, much less, at least in my experience, much less likely you're going to get that notice that we think you may no longer be disabled and we're looking into this more thoroughly type letter coming in.
At that point, that's not a final decision. They're just putting you on notice that, hey, we're looking into it.
Sometimes it's a notice that we are looking into this. Tell us what doctors you've been seeing, etc. And then others, it is we've looked into it and we think you're no longer disabled. You have the right to appeal that decision. And the notice will tell you there is a deadline, a very quick deadline on it, that if you appeal within that deadline, you will continue to receive your benefits while that appeal process is taking place. Used to be 10 days. I haven't been involved in a few years, and sometimes they adjust those deadlines. Used to be 10 days from your receipt. You had to notify them that you wanted to appeal that process, and then you didn't have to file the appeal, but you could call your local branch office, say, I want to continue to receive the benefits while I am pursuing this appeal, and that satisfies it. You would continue to get your benefits while you're going through that process of establishing that you are still disabled from that standpoint. But sometimes it is And I think a lot of it comes in. Some people have Medicare as primary and Medicare as secondary. And if it's primary, then Social Security knows, okay, he's still seeing a neurosurgeon, he's still seeing, or she's still seeing the kidney specialist, whatever it may be, in that regard, and that's your health issues. And kind of that suffice. It'd be a fairly quick process. If Medicare is secondary, you're on a spouse's insurance from their employment, and it's a large group plan, and Medicare is secondary, then Medicare may not have all the records because they don't get everything sent to them in that regard, or potentially an Advantage plan as well. And so they may reach out and say, tell us what doctors you've seen so we can, and sign these authorizations so we can get your records and do this continuing disability review.
And if you receive a letter like this, is that a moment where you should contact the attorney who handled the case or another attorney, or is this something you can kind of do on your own, at least in the initial stages?
The initial stages of letting them know what doctors you've seen, and signing the authorizations you can handle on your own. To some extent, it's fine to reach out to an attorney if you had an attorney represent you in the case originally. Reach out and then talk with them about the process. I've had clients do that, or if they send you forms to complete about your daily activities and things, I've had clients reach out, and then I kind of walk them through that process there. And if it's just, one or two phone calls or something like that, or just one office meeting, then, no harm, no foul situation with them as far as fees go. And then if it is, but if you get the letter saying, we've looked at it and we now think that you are no longer disabled, even though you need to initially, when you get that, call your local branch office and tell them you want to appeal so that your benefits will continue. During that appeal process, you need to reach out to an attorney at that point in time.
Okay.
If you had one originally, reach out to that attorney. If you didn't have one originally, reach out to an attorney that handles Social Security disability cases to talk with them about that process.
That makes sense. And as we were getting into this topic, or at least this aspect of it, you said, okay, it could be if you've stopped going to medical treatment, if you're no longer seeking medical treatment.
Right.
Is there another activity or non-activity that could actually trigger this?
Well, yeah, sometimes the judge specifically says in the decision, if it's depending on the nature of the condition, in the fully favorable decision, the judge says this is a condition that with additional treatment may get better. So I recommend a continuing disability review in 2 years or 3 years. Usually it's longer distance than that, but the judge can put in the fully favorable decision a recommendation that a review occur because there is potential for treatment improving the condition. Some people aren't able to get treatment because they have no health insurance. And then, so once they get on Medicare, then they can get treatment for their condition. And so the judges say, I think this ought to be reviewed to see if the person, if it's somebody who's got significant back injuries and back conditions, but they can't have surgery because they don't have health insurance. Once they get on Medicare, they may be able to have that back surgery. Their condition may improve to allow them to return to work. So the judge says, review this in 2 years or 4 years or whatever there, and that can trigger it being reviewed again in a sooner fashion.
Since the Social Security Administration knows the name of the attorney that was representing the client in the original claim, do they also contact the attorney, or do they just go to the individual?
Normally just go to the individual.
Okay.
I don't recall.
Don't assume.
Correct.
Don't assume your attorney got that letter.
Yes, assume they did not get that letter, because I don't ever recall Social Security sending me the continuing disability review. I think by Social Security standards, and I think correctly, is once the original case is over with and the attorney fee is paid, then the attorney services are finished at that point, and it's up to the individual if they want to hire another attorney to represent them to reach out to the attorney at that point and say, I've got this new issue I'd like you to address for me, and talk about that instead of assuming that the attorney is continuing in the representation. So
that's a real good point.
Yeah.
Jeff, let's transition in our discussion today. Another thing that may come up down the road after the initial claim's already been settled, everything's been taken care of, is the individual who was injured or disabled may receive something called a notice of overpayment.
Correct. And actually, it's kind of one of the final issues that can trigger a continuing disability review. So I'm learning how to do these transitions.
This is a good segue.
But one of the things that can trigger that is if you are showing consistent earnings. And then, Social Security does have a trial work period that they allow, but if you have consistent earnings over a period of time, then they can do a even if you're staying below what's called the SGA or substantial gainful activity level. If you're above that for a certain number of months, you're automatically considered no longer disabled because you're earning substantial gainful activity level. If you are consistently below that, but kind of staying just a little bit below that, they can look at it and say, we think you're intentionally keeping yourself below this. We think you're potentially capable, so we're going to do a continuing disability review. But also working can result, especially if you're on SSI, can result in an overpayment of benefits that then you may have to turn around and reimburse that. So earnings can trigger an overpayment issue. There's an offset if you receive workers' comp benefits that can offset what you receive in Social Security disability benefits, because Social Security has a cap on what you can receive between workers' comp and Social Security disability. Is called your 80% of your ACE or average current earnings figure, and if you go over that, then your Social Security goes down. And so if Social Security finds out you're receiving workers' comp payments or have received a workers' comp settlement, then they can look at it, and that can trigger an overpayment letter going out and saying, we've looked at this, we think you've been overpaid X amount of dollars, and you need to reimburse us within a certain payment period. Usually they like 30 days or 45 days. Wow. You need to reimburse us the money that we've overpaid you.
And I think we've addressed this in different previous episodes. That would have to do with what you call a Social Security wraparound. Is that kind of what we're talking about? Where
Correct.
If there's a workers' comp settlement involved, the way you word the settlement terms can actually protect the client, and he or she needs to be mindful of that.
Correct. You can. Social Security does allow in a workers' comp claim for someone who's receiving disability, and I've represented people who, because of the work injury, they were totally disabled and receiving Social Security disability, and I've handled both claims for them. And Social Security does allow you to word settlements in a way that tends to at least have as little effect on Social Security as possible. Sometimes you can't word the settlement to where it gets rid of the offset completely, but you can stretch the benefits over a longer period of time. Instead of paying a higher dollar figure per week for 8 years, you can pay a lower dollar figure over 15 years. And they go by the weekly rate from that standpoint, so that the rate does not go over the level of the cap that Social Security's put in place, or at least barely goes over it. So there's a little offset, but not a great deal of offset in that regard. And so there are ways to word the workers' comp settlement that way. Now, judges, if a case goes to a judge's decision, it's whatever the judge says, or you can't word that any differently. The judge words that, and the judges, in a workers' comp case, the plaintiff and the defendant can agree to extend benefits for 15 years. A judge cannot do that. It's benefits for 425 weeks, 520 weeks, or till age 70 if they're totally disabled type things, and the judge can't adjust those, whereas by agreement of the parties, they can adjust those. So that is one way to avoid an overpayment. And your attorney in the workers' comp, one of the reasons, if you're on Social Security disability, or even just pursuing a Social Security disability claim, if your workers' comp attorney is not the one handling that case, you need to make sure that your workers' comp attorney knows you have this Social Security disability case going forward, and make sure they're in touch with your Social Security disability attorney, so that they can coordinate, so that when they settle your workers' comp case, if they are able to settle it, that they take into account the effect it could have on Social Security and word the settlement agreement in a way to have as little effect as possible. And that's another reason why, at least in my opinion, it's a good idea to have one attorney handling both claims, because obviously they know everything going on in both cases. Or one office anyway, doing that. So,
yeah, that makes a lot of sense.
right.
So, Jeff, you had told me that if someone were to receive a notice of overpayment, there's really two ways to handle it. You can dispute it, or you can go for a waiver.
Correct.
You want to walk through these options?
Sure. A disputing an overpayment, and I've done that for clients in the past where I handled the Social Security disability and the workers' compensation case, and I settled the workers' comp case to where it should not have had an effect on the Social Security disability claim, and Social Security disagreed with me initially in that regard, and they said, no, there has been an overpayment. Your client owes us back X amount of dollars. And we challenged that and appealed that finding that there was an overpayment. I've actually taken them to all the way to Social Security judge's hearing in front of a judge a few different times, and thankfully have been successful every time I've done that. But that is one way to do it is, no, you're incorrect. I was not overpaid.
And that's disputing the notice. Right?
That's disputing and saying, no, you've made a mistake. I was not overpaid benefits. And it can be like in my situation where I had worded the agreement the correct way, and they were misreading the way I'd worded the agreement, or weren't taking it all into the way it should have been taken. Or it can be a situation where something may not have been reported correctly to Social Security. If it's an earnings issue, for instance, if Social Security thinks you earned a certain amount and you didn't earn that amount, like if you're on SSI, and for some reason a number got transposed, and you made $300 this one month, and somebody put in 3,000 or something like that. So there could be a human error,
a keystroke issue.
Yeah, something like that, and that's a situation where you want to go, no, that's wrong. Here's the paychecks I got this month. I did not get the amount that you said I got for that month. There was no overpayment. So you're disputing their finding that there was an overpayment in the case.
And then the other option is to seek a waiver.
Yes, you can also seek a waiver of the overpayment, and there's a couple of things you have to establish there. One is that the overpayment wasn't your fault. So, like on a workers' comp case, if you fail to notify Social Security that you got this workers' comp settlement and provide them a copy of the settlement agreement, and then a year later they find out that you've got this workers' comp settlement, and they go look at it, and they say, you've been overpaid because you didn't tell us about this settlement, you're going to have a real, real hard time convincing them they should waive the overpayment, because in their mind, you created the overpayment by not notifying them. If you send them a copy of the workers' comp settlement agreement, then and then they take 6 months, 8 months to process it, and then come back in and say, okay, you've been overpaid here, then you can say, I sent it, the judge entered it on January 15th. I mailed it to you on January 25th, and it took you this long. I'm not responsible for all of this overpayment. But you also have to show not only that you didn't cause the overpayment, or at least some way responsible for it, but also have to establish that it would be a financial hardship for you to do that. For instance, if you're receiving Social Security disability, you got a large workers' comp lump sum amount, and now they're saying you were overpaid $10,000, and you've got $40,000 left of the settlement in your bank account, they're not going to overpay. They're going to say, no, you've got the means to pay us back in that regard. So a waiver is going to have very little chance there. If it is a situation where, you're on SSI, or, a low disability payment and all the money have been spent and you have very little money in the account, and then asking for a waiver in those situations, you're much, much more likely to grant it. When you have that financial need and it's going to create a significant financial hardship for them to collect the overpayment, much more likely that it's going to be waived in that regard, or potentially take out a small amount from your future monthly payments to pay the overpayment back.
Just like paying it back over time.
Correct. Paying it back over time to where it doesn't cause as much of a financial hardship on the person from that regard.
And as I'd asked in the previous topic section, is this something now where they need to engage an attorney, either their previous attorney who handled the claim or a new attorney, when it comes to either disputing it or seeking that waiver?
I would, yes, in my opinion, you need to reach out to an attorney at that point in time, especially if it's like a workers' comp offset issue. You need to reach out to the attorney who handled the workers' comp claim and your Social Security disability attorney if it's two different people, and address that issue with them to challenge. Hopefully it was worded correctly and you can challenge whether there was an overpayment, but you need to reach out to them because they're the ones who are going to know what the caps are and all of those things to be able to handle that for you in that from that standpoint. Now, you may have a little bit of an issue if you didn't have an attorney handling both of those, because if you settled the workers' comp claim yourself, you probably, unless you know about the offsets and how to work the wraparound language, you probably do have an overpayment, and it's going to be a little harder to undo that, and very well may be impossible to undo that. So those are reasons that, yes, you need to reach out to an attorney from there. If it's a work issue later on, then yes, if you had an attorney handle the Social Security disability case, reach back out to the attorney who handled your case for you and talk with them about that issue. And if you did not have an attorney, then it's probably time to reach out to an attorney to see if they can help you with that issue.
That makes sense. Well, Jeff, let's transition to the third topic today, and this has to do with relocation issues. Now, a relocation, this is when somebody's obviously moving from one home to another home, and that can present some problems. That can happen potentially while they're in the midst of actually handling the claim, while the claim is still active, and then again, after the claim's been settled down the road, they decide to move somewhere else. Let's talk about how this can also be a little disruptive to the case.
Yeah, if it's during while the case is ongoing, what's going to happen if you move? First off, you need to notify Social Security of the move, and if you just move one street to another street in the same community, not going to be a big deal from that standpoint. But if you change states or if you move a good distance away, even in the same state, then you may be in the area of a different hearing site. And so your case may be transferred to a different hearing site in that regard if you're at the hearing level. So if you're in Murray and your case is here and then you move to Nashville, the case is going to be transferred from the Paducah hearing site to the Nashville hearing site, and vice versa. If you go from Nashville to Murray, it's going to be transferred from Nashville to the Paducah hearing site. And so that has an effect on it. And if I know you'll recall this, but if listeners recall previously, we had a podcast episode where I strongly recommended that you have an in-person hearing instead of a video conference hearing. So if you switch hearing sites, you're switching the judge. It's going to be the one who's going to be deciding your case in that regard. And that can make a difference, positive and negative, because judges have different passage rates. And so if you go to a judge who is, has a good passage rate and go to a judge who, only approves 10% of the cases that are in front of them, that can have an effect on your case and vice versa. Now, you don't need to forum shop from that standpoint, but that is an issue that you have to deal with if you change your areas. And from an attorney standpoint, that can have an effect on it. As I've mentioned before, I handle cases technically I'm licensed by the Social Security Administration in all 50 states. And if you are a client of mine and you move to Hawaii, I will still represent you and go to Hawaii for the hearing. If you're a client of mine and you move to Alaska and you think I'm going to Alaska in the wintertime for your hearing, no, I'm referring you to an Alaska attorney in that regard. So it can't have it can be a situation where it affects whether the attorney can continue to handle the case. If you move if you only move a couple hours away, no big deal. If you move from Murray to California, I'm not flying to California. It's not cost. It's not the best for the client even in that situation because I get reimbursed my expenses and a flight to California, a hotel room, fly back. When I could refer you to a California attorney who's not going to have those extra expenses there, better to refer people out. Now, I've had some clients that wanted me to travel. I've had hearings in Alabama and various other states in that regard, and that's fine, but it's just up to the client. And I always let them know, well, you're going to have more travel expense for me to come do this hearing in Decatur than you would a local attorney. And if they want me to continue to do that, that's their call at that point. So
exactly. But once again, let me establish for the record, we're still open to that Hawaiian client, and please call Jeff.
Exactly. Please. Yeah. And Jim will volunteer to be my paralegal for that.
I will be your lackey. I will be your lackey for that. Carry your bags, Mr. Roberts. So we'll be good to go. And so again, after the claim has been decided,
yes,
down the road, okay, how would a relocation impact it at that time?
It's not as big of an impact as a general rule, especially if you're on Social Security disability. It's really not going to be much of an impact if you keep the same banking account because checks now are direct deposited. Used to they were mailed and then you had to notify them so you could get your checks. But if you're keeping the exact same bank account that you had when you were at before, then very little effect on Social Security disability. From that standpoint, if you move and you're on SSI, that can make a difference from that standpoint, especially if you move states, because then with SSI, you're on Medicaid instead of Medicare. And Medicaid is usually, well, not usually, it's state-based. So if you're on Kentucky Medicaid and you move to Tennessee, then you got to get on TennCare or Tennessee Medicaid instead of Kentucky Medicaid because you're now a Tennessee resident. So it affects the medical side of it for an SSI person that you got to go through that process to get the medical insurance transferred to your new state. And some states have a little bit different payment amount. I think it's based, I'm not sure why, and I assume it's still this way, I think it has to do with cost of living, et cetera, in the states. But at least used to be if you moved from one state to another, it could affect how much you received in SSI benefits. And so that is something else that can be affected there. Now, if you still got the same bank account, probably not going to affect you getting the payments from that standpoint. But if you change your banking, anytime, even if you stay in the same address, if you change your bank account, you've got to notify Social Security so that they make sure the check gets direct deposited into the new account,
into the proper account. Right, that makes
proper
sense.
account,
and that's on the client's shoulders. That's on their their responsibility.
It's our responsibility,
yeah.
And I've had a couple of clients do this in the past and call me up because of issues, and I always tell them going forward, if you switch banks, keep the one account open that the direct deposit's going into. Keep that account open until you see the direct deposit going into the new account. Because if you notify Social Security and then you change the bank from that, it can take a couple of months for Social Security to process that and start depositing into the new bank account. And if they're still sending it to the old account and that old account is closed, you don't have access to that money, and it may take a while for that process for them to get it to the new account. So keep that old one there open until they start depositing it into the new account.
That's real good advice. I hadn't even thought about that aspect of it, but that makes a lot of sense. Jeff, today we're down in Murray, Kentucky, and we're recording in your office here in Murray, but you also have an office over in Christian County in Hopkinsville.
I do. I have an office over there, been open for a couple of years now. I've always had a lot of clients, as mentioned earlier, I'm licensed by Social Security in all 50 states, or to practice in front of them in all 50 states. I am licensed in Kentucky to handle a case anywhere in Kentucky. Most of my clients, actually, I have a lot of clients in the Murray area, Calloway County area, but I have a lot of clients outside of that area, and I've always had a lot of clients up in the Christian County area from that standpoint. So opening that office up there is allowed me to provide better service to those clients from that standpoint. But I only have one phone number. I found that that's a lot easier for me and for my clients to have one number from there. So the phone number is 270-753-0053. You can call that number and you should get a live person to answer that. That's part of, as we've referred to before, I do have a motto for my office that we try to abide by, and that's to provide small town service and deliver big city results. And part of providing that small town service is having a live person that you talk to when you call into the office, instead of getting a computer or an answer machine that's talking to you. And the live person is someone here in my office in Murray, and so that's the person you're getting. It's not a call center somewhere else either. So you're actually getting someone who works for me to that, and that's, to me, that's one of the ways we try to provide service, the small town service to our clients, and kind of hopefully stands us apart from some other law firms in that regard, in the service we do deliver to our clients.
Outstanding. Jeff, I really appreciate your time. I mean, today we went over really three primary issues related to Social Security disability. We talked about continuing disability review. We talked about a notice of overpayment. And then we talked about relocation issues, all of those of which can actually cause a speed bump, not necessarily a major problem, but it could definitely something that needs some attention.
Correct.
And you shouldn't wait. When those happen, you need to take action. Don't ignore them.
Exactly. And if you already have an attorney, notify that attorney. If you don't have an attorney, but you did, contact that attorney or contact a new attorney so that those any bumps in the road can be addressed by them.
Outstanding. Jeff, thanks for your time. We'll be back in a couple of weeks.
Thank you.
Bye-bye.
Bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.